All right, good morning, everybody. I am Hank Lerner. I am PAR's Chief Legal Officer. I'm joining you today from an undisclosed location outside of the PAR headquarters, which I tell you both because it's true, but also just as an added warning, because if I have little weird Wi-Fi issues or you hear motorcycles or something outside the door, please bear with me because the noise and the tech here is going to be a little bit different than usual. We are here today to talk about Contracts 101. Today's session is going to be with the entire legal team here, all four attorneys that work for PAR. I've already introduced myself. Also on the phone today is going to be Desiree Brocker, our Assistant General Counsel. In addition to that, we will have Casey Klauser, who is one of our associate counsel, and our newest attorney here on the call today, Paige Perucci, who joined us about a month and a half ago, also as associate counsel. So we're all going to be discussing Contracts 101, some of the basics that you need to know about contracts, not really talking about specific contracts all that much, so much as we're getting into some of the real basic information about what makes a contract. So sort of making them and breaking them, how contracts work. What are we going to be talking about a little bit here more detailed? The first section we're going to be talking about will be formation. How do we form a contract? The second section is going to be contract terms. So if you have a contract, what are the terms of that contract? How can you tell what they are? The third item is going to be termination. So what happens when we don't want to have a contract anymore? And then the last section is going to be release. So releasing the parties from the contract and also dealing with how do we release the deposit monies, in particular when we're talking about the agreement of sale. So those are our four main topics we're going to go through here today. And we're going to start off with contract formation. And we're going to hear from Desiree on that one.
Thanks. Good morning. We're going to start today by talking about contract formation, in particular, the minimum requirements for any contract. In very basic terms, there are three elements required for the formation of any contract. Those elements are offer, consideration, and acceptance. And we're going to talk about each of those elements in turn here. So our first element is an offer. Legally speaking, and in very general terms, an offer is a demonstration of someone's wish to enter into a bargain. Offers are usually made on the PAR agreement of sale by the buyer. The buyer fills out the form with the terms that they are asking for and presents it to the seller or the seller's representative. This is the buyer's demonstration that they would like to enter into a contract with the seller. However, the offer is typically limited in different ways. We're going to focus on one of those limitations, and that is the duration of the offer. So paragraph 5A of our residential agreement of sale sets a deadline for the written acceptance by a seller. There are similar provisions in every one of our standard form agreements of sale, but I'm going to be referring to the residential agreement. If there's no acceptance by that date in paragraph 5A, then the offer will naturally expire. A question that we get asked quite often is what happens if the seller signs the offer after that deadline? Is it a binding contract? The answer, as usual, is it depends. It's not automatically binding, but it can be. A seller can't lock a buyer into the contract if they sign after the offer has expired. However, whether the parties actually have a contract depends in part on how the parties are going to behave at that point. Do they demonstrate a willingness to be bound? Is the buyer willing to ignore that late acceptance and be under contract? If so, then it makes sense to modify the acceptance deadline in paragraph 5A as part of what is essentially a counteroffer by the seller. But basically, any attempt by the seller to accept the buyer's offer after the expiration date will be honored only at the buyer's discretion. The second element for a contract is consideration. Many of you know that consideration basically means something for something, and that is correct. However, what many of you get wrong is the idea of what consideration can be. Consideration is legally defined as a mutual exchange of promises. In terms of your real estate contracts, the buyer promises to buy a property and the seller promises to sell a property, all with terms and conditions, of course, which Paige will talk about more in a little bit. This is because valid contracts typically are not one-sided. Think of that awful relationship you were in when you were younger, where you just gave and gave and gave and got nothing in return. If it's not mutually beneficial, then there is no consideration and it's not going to support a valid contract. The thing that consideration is not is a monetary deposit. Please listen carefully. Consideration is not a monetary deposit. So if you think about it, can there be contracts with no exchange of money? There absolutely can be. There can be a contract where one party promises to give someone 10 balls of yarn and the other person promises to return a hand-knitted blanket. That's a contract. The parties have exchanged promises, but no money. The real estate contract contains a promise to pay. The deposit is mainly for providing the seller with a remedy in the event of a default, but it is not a legal requirement. The last element of contract formation is acceptance. Acceptance is legally defined as an act which shows agreement to the terms of the offer. In most cases that you will see, the act is the seller signing the agreement of sale. Notice that I said the seller signing the agreement of sale, and it's because we're looking for evidence that the parties intend to be bound or that the parties agree to the terms. A text message from an agent saying you've got a deal or something of that nature is not necessarily binding on the seller. We're looking for the parties' assent. Remember that the written acceptance is on a deadline. One of the terms of the offer is the timeline for accepting it. The seller can't bind the buyer to the contract after the deadline has passed, nor can they unilaterally change those terms of the offer. So next up, speaking of terms, we will hear from Paige telling us more about contract terms.
Thanks, Desiree. I'm going to speak a little bit about contract terms, specifically what the terms binding on parties and the four corners of interpretation mean, and what is the correct process to change terms with a contract. So first, looking at legally binding contract, binding on parties. A contract is a legally binding agreement between two parties. If one party fails to follow through with a legally binding contract, the other party can take legal action against the breaching party since it is an enforceable contract. The elements necessary to have an enforceable and legally binding contract is listed here. As Desiree had mentioned, the offer and acceptance of that offer and consideration. You also have to have intention, so intent from both parties to enter into the agreement. When the courts are looking at intention, they look at the overall actions of the parties. You also need legality, an agreement that is considered legal under the law. An example of this is you enter an employment contract with a drug dealer to sell drugs, and he never pays you. Well, it's not a legal contract because it's illegal to sell drugs. Contracts that explicitly break the law or go against public policy or fair dealing are considered illegal. You also need capacity. Both parties have the mental capacity to understand the agreement and what the terms they are agreeing to. People with mental disabilities and seniors with dementia are some examples of parties that may not have capacity to understand or enter into a legally binding contract. If you have all of those elements, when you enter into a contract, then the contract is binding and enforceable in the court of law. The next term we're going to go over is the four corners rule, or the four corners of interpretation. This is a legal theory that every lawyer learns in their first year of law school. It asserts that the terms of the contract and the parties' intentions can only be determined by the written agreement itself. When both parties enter into a legally binding agreement, all the terms and conditions should be explained in detail in the final signed contract. Any part of the agreement that's not included is not enforceable. So as an agent or a broker, you want the best representation for your client. Make sure nothing is implied. Walk your client through every part of the agreement. If something is not included that your client wants, it can be fixed immediately before signatures. For example, paragraph 7 of the residential sales agreement states that the buyer and seller are encouraged to be specific when negotiating what items will be included and excluded in the sale. You want to also look at paragraph 25A of the agreement of sale. I like to call this the speak now or forever hold your peace. There's a section in that agreement, in that paragraph, that states this agreement contains the whole agreement between seller and buyer, and there are no other terms, obligations, covenants, representations, statements, or conditions, oral or otherwise, of any kind whatsoever concerning this sale. This agreement will not be altered, amended, changed, or modified except in writing executed by the parties. So once it's signed, whatever's in there is enforceable. Anything otherwise, conversations prior to the agreement are not. Now, what if both parties want to change the terms? First, speak with the other party to have full communication. See if they are willing to negotiate and make an addendum to the transaction. If you don't have their consent, then you cannot change the contract and you're bound to the terms as stated in the original contract. I'm sure many of you have used the PAR change in terms addendum form. When using this form, be concise with the information, whether it's costs, repairs, even model numbers. Both parties must sign for it to change or amend the terms in the original contract. Lastly, making sure you're informing your clients of all possibilities when changing the terms. Remember, you're the licensed professional, so be sure to explain in depth to protect your client and yourself. For example, think about buyers applying for a different mortgage lender. The buyer is bound to the original lender in the mortgage contingency section of the agreement of sale. So this is a perfect example for when the parties should utilize the CTA form with PAR. Now I'm going to segue to Hank with termination.
All right, so contract termination. Of course, as you said that, there was a very large and loud vehicle going by outside my door. So, contract termination. This is the part where people really start to get hung up. So there's some questions that we get on the hotline about, is this really a contract? Did I create the contract appropriately? What if here or there? We get a bunch of questions about things that are included or not included in the contract. When I texted and said, you know, my buyer wants the fridge, was that enough to include it in the contract? You know, Paige says no, right? It has to be actually in the contract. That's what we're talking about. But that's really the preliminary stuff where the real difficult questions often come in is in termination, because now you're in contract. Everybody agrees that there is a contract. Everybody agrees that the contract has some terms of some sort, whether that's what they actually wanted or not to begin with. And then somebody decides that they don't want to be in the contract anymore. So how do we end the contract? And are there things that you need to be aware of when it comes to ending contracts? The answer, of course, is yes. Otherwise, we wouldn't be doing this seminar, right? So there's a couple different ways that you can look at ending the contract. The first one is termination by a contractual right. So you have a contract and the contract says things. One of the things that the contract says is under the following circumstances, one party or the other has the right to terminate. So think about the inspection contingency. The inspection contingency in the PAR agreement of sale says that if elected, the buyer has certain rights after they get their inspection results back. One of those rights may be the right to terminate In fact, that right to terminate may come at different points in the inspection process, depending on how the negotiations go. One of the really obvious ones here is the condominium homeowners association section. So there are specific state laws, which are reflected in the language of our agreement of sale, that say that a buyer has a certain period of time up to and then after receiving the various resale documents from the condo or HOA, that they have the unfettered right to terminate the contract. So it's in the contract, but that's even a legal right beyond the contract that says the buyer can terminate if. Think about our mortgage contingency. The mortgage contingency says that if there's no mortgage commitment by a certain date, the seller has the right to terminate. That's really important, that word seller there. We're going to come back to that in a few minutes. So there's some examples here of things that our contract specifically says, if this happens, then one party or the other have the right to terminate the contract. When you are terminating under a contractual right, however, you actually have to use the contract as written in order to exercise that right. So we have people who call who say, well, my buyer wants to terminate because they got an inspection report back and the inspection report shows something that they don't like. And then we say, oh, okay, well, which inspections did you elect in the agreement of sale? And the agent says, oh, well, we waived the inspections. Okay. The contract says if you get a result back that you don't like, you could potentially terminate, but only if you actually elect the contingency. You can't just use the words in the contract to justify your outcome because you've waived that language and you're not actually taking advantage of it. Or again, in the inspection contingency, it's very specific that the buyer's right to terminate initially is within the first contingency period, which is 10 days specifically in the agreement of sale, unless you change that. So buyers will show up 15 or 20 days later and say, oh, there was something I didn't like, I want to terminate. Well, that's not what the contract says. The terms of the contract, the four corners of the contract say you can terminate within a certain period of time. You cannot just make up new terms to justify terminating outside of that. So you have to look at the timelines, you have to look at the criteria for those contractual rights, and you have to follow through with them. I like to use the example of employment and employment contracts in this area when we talk about termination. So if you think about all the news stories that you might see about a CEO getting fired, for example, and then there's a story that follows up about whether they're going to get their multi-million-dollar golden parachute because there's questions about whether they violated their employment contract. So they get investigated and people look and say, oh, well, you know, is there a morality clause that says you're not going to get paid if you get fired for doing the following things? Or is there something that says if you get fired after a certain period of time, you get more money than if you get fired before that time limit? So there's going to be things in the employment contract that say, I can fire you if, and then they set out the criteria for that. Or even just think about your own office. So think about if you run a brokerage and you have, say, an administrative assistant, a secretary, a transaction coordinator who's on staff there. If you sign an employment contract with that person that says, if you are, late to the office more than 3 times in a month, I can fire you. You have to use that term. So if they're late twice, you don't have the contractual right to fire them. You have to look at the terms of the contract. You have to decide what is it that we're doing and are we following the rules of the contract. So super important to understand what's in the PAR contracts. This applies to our listing contract, our buyer agency contract, right? Like firing the buyer, firing the seller, or them firing you. It applies to our agreements of sale, all of the agreements of sale, things that can be canceled or not. Look at the terms that are in the contract and follow the contract terms. There's another category that comes up a lot, and this generates a ton of our legal hotline questions, which is every other reason that a party comes up with to decide to terminate. So basically, these are things that you've made up. There's really no other better way to put it. It's a buyer or a seller who says, well, I don't want to be in this contract, therefore I'm going to suggest a reason that I think I should have the right to terminate, even if it's not actually supported by the contract. So remember, I talked about remembering sellers under mortgage. In the mortgage contingency, the seller has the right to terminate if a commitment is not obtained by a certain date. There is nothing in there that says that the buyer can terminate if they do not have a commitment by that date. Probably 5 to 10 times a week minimum, we get buyer agents who call in and say they lead with, my buyer did not get financing, so we terminated and we have to have very uncomfortable conversations to say, well, can you point to the area where the contract said the buyer has the right to terminate? Probably not, because it's not there. So if you have a buyer who has not gotten their mortgage, please do not do that. Read the contract terms and decide how you go forward ahead, how you move ahead. Seller disclosure. Buyers all the time want to say, well, there's something that I think you should have disclosed, therefore I want to terminate the contract. The seller disclosure law itself is very explicit that a failure to disclose is not grounds to terminate a contract. It says so right in the law. There are other remedies to a buyer, but simply terminating the contract is not one of the remedies that is available to them, in this case by law. On the seller side, just to make it clear that it's not just buyers who are making things up, particularly in the market the way it's been recently, sellers are saying, well, I couldn't find another house to buy, therefore, gosh, I just guess I can't sell you this one, so I'm going to terminate. Again, not a contractual term in the PAR agreement of sale. Now, we're going to stop here for a second and point out that you may have noticed that we're only talking about things that are pre-printed in the contract. If you and your parties want to add language to the agreement of sale, that is something that is legally possible. We have to caution you, however, make sure that you have it reviewed ideally by an attorney or written by an attorney, run it by your broker, brokerage counsel, make sure that there's somebody who's really looking at this language to make sure that it works, because more often than not, when we get questions coming into PAR about added language, it's added language that does not do a good job of actually setting out what the criteria are, and how you can decide if someone is going to actually have the right to terminate. So for example, if a seller decides to add language that says contingent upon seller finding suitable housing, and that's the only language that you add, I don't know what that means. Those words do not have any particular meaning. They're going to be very, very difficult, if not impossible to enforce, because nobody knows what suitable housing is. Nobody knows what timing you're looking at. Nobody knows what rights you have to terminate. Has the buyer gotten any protections against a seller terminating randomly 2 days before settlement because they've decided they don't like the house that they were going to buy anymore? So when you add in language, you more often than not, you're going to be creating one of these imaginary situations because you're adding in language that doesn't actually have very specific terms. The last item here, of course, is sometimes a buyer or a seller just decide they don't want to buy or sell. So they just terminate on their own and they just walk away and hope that nothing bad happens. So again, think about employment contracts. In Pennsylvania, most employment is at will. So do you have the right to terminate someone just for any reason? Perhaps you do, because employment is at will. So in that case, you could just fire them. If there's terms, you have to follow the terms. If there's no terms, you have the ability to fire someone at will. But there's a difference between having the ability to end a contract and having a right to end the contract. So if I were to, which is not going to happen, just to be clear, but if I just sort of did this on the screen and I landed on one of the squares of the other attorneys and I called them in and said, hey, by the way, you're fired because you're an employee at will and I can do that if I want. I might have the ability to do that. I would be crazy, and somebody might hunt me down in the parking lot afterwards if I did it. But do I have the right to terminate them without actually having any damages against me? And the answer is perhaps not. Because if you end a contract, you end a relationship like that, the person on the other end might come back and say, well, I think I should have some protections here. So maybe they would sue for, unlawful termination. They might say, I want to get paid for the remainder of some period of time, or you have to make it right in some other way. So can you terminate a PAR contract for no good reason? Sure, your client has the ability to terminate, but if they don't have the right to terminate, it might cost you. So it might cost you if you're a buyer, it might cost you your deposit. It might cost you more than your deposit if the seller has the ability to come back and sue. If you're a seller and you decide to terminate, it might cost you your house because the buyer might sue for specific performance and ask you to actually sell them the house at the contract price, or you might be sued for additional damages. So just because you can end the contract for any reason, literally, doesn't mean that you can do it without any damages. So the protections that we have built into the contract, when you're talking about the agreement of sale, the buyer's deposit, while not necessary for consideration, as Desiree covered, does help with the protection for the buyers. Protection for the sellers to make sure that a buyer just doesn't walk away because they have something on the table that might be taken from them. On the seller side, if a seller terminates, there is no specific remedy in our agreement of sale. However, it does say that the buyer could sue for whatever remedies are otherwise available. So that's the protection for the sellers, that they might end up being sued in court. So when somebody says, I'm terminating, there's nothing you can do, that's wrong. There's generally something that can be done. It just might take, again, a visit with an attorney to figure out the details there. So how would one go about terminating the PAR agreements? Well, as often is the case, we've got a form for that. So we have a form called, cleverly enough, the termination form, the form TER. So if you need to terminate one of the agreements of sale, that is the place to start looking. We also have a combination form that has the termination, the TER, and the release form, the AREL, because we want to make it a tongue twister, but also make sure that it's very clear what the form is. It's the TERAREL because it's those two forms mashed together on one piece of paper. Both of those forms, the termination and the combined termination and release, the termination section is the same. And the key to the termination section is that it asks the terminating party to cite the grounds for termination. So it asks you to cite the paragraph number so that you can give the reason why you are terminating. Is there a legal reason, a legal requirement that you do that? No, there's no legal requirement that you say specifically why you're terminating. The reason we do it, though, is to make the parties think about why you're terminating. So if the buyer says, "Oh, I want to terminate under the mortgage contingency," well, next question is, okay, let's read the mortgage contingency. If we're going to cite that paragraph, let's read it and make sure that that paragraph actually supports our desire to terminate. If we read it and find that it never says buyer terminates, maybe before you send something over to the seller, you're going to stop, you're going to think it through, you're going to talk with your client on the buyer side and say, gosh, maybe we don't have the right to do this. At the same time, if a buyer just says, I terminate because I can, and send something over to the seller might not understand why the buyer is terminating and might think that they're doing it wrong. So citing a paragraph in that form allows the seller to understand why the buyer has terminated so that maybe they're not going to start a fight because they understand already what the terms are from the buyer side. The seller, the listing broker, can sit down and understand that. So, Casey will be talking in a couple minutes about the other part of that form, which is the release, which is why we're not talking about it here. I'm going to cover just one more section here, which is expiration. So we get a fair number of calls from people who basically have gotten past the settlement date, and they're now fighting over which party is going to actually send the termination. The answer is when the contract has expired, it has already expired. You don't need to actually terminate the contract. So at the end of the contract, if you get to the closing date and the parties are unable to close, time being of the essence as it is in our contract, if you're supposed to close on the 15th and it's now the 18th, you obviously cannot perform. The contract is over. Neither side actually has to say the words, I am ending the contract. The contract is already ended. It may help, though, to communicate that, to go back and forth between the parties so that everybody understands that the contract has ended, but you don't have to use the termination form, and neither party has to sort of take the initiative to do the termination. But it's also important to remember that just because the contract expires doesn't mean that nobody's at fault. So if the contract expires because the buyer was unable to get financing and therefore could not close in time, that doesn't mean that the buyer's off the hook, because if it expired because the buyer didn't have financing, because the buyer failed to provide their employment information, or in a recent call we had, one of the spouses quit their job shortly before closing and therefore they stopped being able to afford the loan. There still could be fault for the party that caused the contract to end. So termination isn't necessary, but just because it expires on its own doesn't mean that either party gets away with it. They may still be chased down for damages depending on the circumstances. All right, that was a long segment from me. We are now going to turn it over to Casey, who is going to talk about release.
Yeah, so as Hank said, he covered the termination, and now going on to, we know about termination, but what is release? The release is both for negotiating the release of any deposits that have been made, but it is also designed for the parties to release each other and their brokers and agents from liabilities related to the contract. Paragraph 1 of the release covers releasing from liabilities under the contract, and paragraph 2 covers release of the deposit money. If there is no deposit money, parties can still execute the release with $0 in the amount for paragraph 2 and fully and effectively release the parties from the contract. Please double check your work. We have had luckily only a few calls over the past couple of years, but they do still happen where one agent puts the distribution of deposit money to the wrong party. Once the other party signs it, the contract is fully released, and now the deposit is returning to the wrong party. So please don't do this. Double and triple check that the party that is supposed to be getting the deposit money is actually the one listed in the release. You may have noticed that while most transactions use a form that combine the termination and the release, those call letters are the TER, AREL, we also have them separate as well, as Hank said. That's because in some instances, there's a desire to do one of those steps separate from the other. For example, maybe you know that the other side will never agree to the release when you send the termination, so it's easier to just send the termination by itself. Or, as Hank noted, if your contract expires, then there's technically no need for the termination form, so just the release form can be used on its own. Unlike the termination, the release must be fully executed by both parties in order to be valid. Once it is fully executed, the contract is officially over. But if an agent were to just send the release form without the termination, and the parties don't agree to the release, then technically the contract has never actually ended if it's before the expiration date. Or to put it another way, simply sending a release is not the same as actually terminating the contract. It is also important to note that if the release is fully executed by both parties, there is no longer a need for termination. So what happens if there's no release? We often get calls that parties are refusing to sign a release form. At that point, the next question is, now what do we do? This is where paragraph 26C of the agreement of sale comes into play. After a certain number of days, the default is 180, the buyer can request the money back from the broker holding the deposit. If the broker is not in receipt of verifiable written notice that the dispute is the subject of mediation or litigation, then they must return the deposit. And they have 30 days to return that money. So this is an administrative 30 days for the convenience of the broker to get all their ducks in a row for releasing the deposit. This is not an extension of the time frame under 26C. So the broker can't call their seller and say, hey, we just received a request. Go file for mediation real quick so I don't have to release it. There was actually recently a real estate commission case regarding the broker not following paragraph 26C. You can find more information in Hank's article from May 26th, which will be dropped in the chat, as well as all of the resources that are sent after the webinar. Verifiable written notice that the dispute is the subject of mediation or litigation is also extremely important. This is not an email from the seller stating that they are going to file for mediation. This is not an attorney letter saying, give me that money back or we're going to file. This is seller actually filing for mediation or litigation and providing that written proof to the broker holding the deposit. On the other side, buyer sending a termination and release at the time of termination is not a written request by the buyer to the broker holding the deposit. They need to actually send that request after the time frame has run out. There is not a form for it, but it does have to be a written request. So including information, identifying information for the transaction to be able to request that money back from the broker holding the deposit. The intention of 26C is to make sure that the broker holding the deposit has an ability to release the money from the escrow in the event an agreement cannot be made, but no one is doing anything about it. So this is really for our brokers to attempt to limit liability by having an avenue if both parties refuse to sign. Any release of deposit money that is done under 26C does not mean that the buyer is legally entitled to that money. It just frees it from the escrow account. Obviously, it's much easier for the seller to go after the money when it is still in the escrow account. However, if they miss the time frame in 26C and the money is released, they would still have the opportunity to go after the buyer for the deposit money. The other issue that we see is that neither broker is holding the deposit, and rather they have a title company holding it. Title companies are not required to abide by 26C. Title companies are not held to the commission regulations, and that is what entitles the brokers to abide and requires the brokers to abide by 26C. If your buyer's deposit is going to be held by a title company, you need to make sure they're fully understanding the ramifications of such. Now that we've covered quite a bit of the high level contracts 101, we did want to take some time to go over the forms release. I know typically around this time, we have members asking about what's coming up next. So historically, we have been releasing forms on January 1 and July 1. In January of this year, the Standard Forms Committee voted to change those dates to February 1st and August 1st, with the old dates falling on New Year's Day and usually around the July 4th weekend. It was a bit more difficult to work with the vendors to ensure that the forms would go live right away and making sure that we are educating all our members appropriately. So February 1st and August 1st will hopefully be a bit easier on the vendor's ability to have tech help available in case of an issue. So with August 1st coming up, we wanted to make sure that everyone was aware that at this time, there will not be a forms released on August 1st. So that is not something that you need to be keeping an eye out for, but it is something to stay on top of the new time frame so you can be aware moving forward.
Yeah, and I guess I literally didn't think about this, Casey, until I was looking at this slide. I'll clarify August 1st, 2023. Because we don't really know how long this video is going to live online, I guess. So we don't want anybody who views it next year accidentally to get the wrong idea. So as of 2023, no release on August 1st, no promises for future years. All right, so that brings us pretty much to the close here. And I'm just going to point out what's going to be coming up next for our legal webinars on PAR's site here. So for those of you who have been following along with what we've been doing here, there's been a series of other webinars where we talk about risk reduction, legal liability. The first one we did last year was called Don't Do That. We then followed up with They Did What, where we talked about specific things that people were doing poorly in our forms or in transactions. Then we talked a little bit more about some specific scenarios where we've seen language in our contracts. The one that will be coming up in October, which you'll see information coming up on a little bit later this year for registration, is going to be called And They Got Caught. So in our October webinar, we are specifically going to be talking about some recent disciplinary cases from the State Real Estate Commission, where it's not just hypothetically what might happen if you do bad things, but actually talking about individual cases that came up, like one that Casey referenced, where people have been sanctioned for doing things incorrectly. So how can you as a broker, how can you as an agent manage your risk to make sure that you're able to stay on the right side of the State Real Estate Commission? So with that, I want to thank everybody for joining us today. And we hope to see you all in October at the next webinar.